Today, we're talking about how to stop a competitor from committing a trademark chainsaw massacre on your brand identity. If a patent protects what your invention does, like the Ouija board's mechanisms I talked about last week, a trademark protects who is selling it. It's your name, your logo, your slogan, a signature scent or sound, signature packaging, and more. And it's how your customers instantly recognize and trust you. Without it, your brand is vulnerable to copycats and imposters, the ghouls of the business world. Let's talk about the horror of consumer confusion. The entire point of trademark law is to prevent consumer confusion. If a consumer sees your logo or name on a product, they need to be certain that it comes from you. If a competitor uses something too similar, they're deceiving the consumer and stealing your hard-earned reputation. A fantastic real-life horror example involves a trademark battle over a film title in the Evil Dead franchise. Back in 2011, Sam Raimi's company, Renaissance Pictures, was gearing up to remake the classic film. At the same time, another company, Award Pictures, announced they were making an unauthorized sequel called Evil Dead 4: Consequences. Renaissance Pictures filed a lawsuit asserting trademark infringement against Award Pictures. Why? Because the name Evil Dead isn't just a film title anymore. It's a brand. It represents decades of history, a specific cult following, and millions in merchandise, video games, and licensing. Award Pictures was essentially trying to trick fans and their investors into thinking their film was an official entry in the long-running franchise, like a demon-possessed friend trying to break through the door in the floor while promising to be good. The court agreed with Raimi, granting an injunction that barred the competitor from using the Evil Dead mark. This is a critical lesson for every independent filmmaker, musician, spooky brand owner, or everyday small business. Your film title, business name, logo, slogan, and possibly other brand identifiers must be protected by a registered trademark, or someone else might take a chainsaw to your brand's integrity because you don't have the sharpest legal teeth to fight them. Now let's go over 4 ways your brand gets haunted. Here's what they are and how to defend against them. Number 1, literal infringement. We'll call this the Doppelgänger. This is the most obvious horror. A competitor uses the exact same name or logo on a similar product or service. This is a clear-cut trademark law violation and the easiest to shut down with a cease and desist letter or lawsuit. Well, maybe not easy. It should be easy, but sometimes you have to spend money on lawyers and going to court because the infringer is delusional and has money to burn. Number 2 is the likelihood of confusion. This is the close call. This is where most lawsuits live. A competitor uses a name or logo that is confusingly similar to yours. For example, if you sell a horror-themed craft beer named Cenobite Suds, and a competitor starts selling an identical product named Cenobite Brews, that's likely a trademark violation. Even though the names are spelled differently and maybe sound a tiny bit different, the sound and the meaning are close enough to cause consumer confusion. Number 3 is brand dilution. Call this the slow rot. This is a subtle, slow burn horror where your distinctive, famous mark is weakened by unauthorized use. This applies if your brand name is very well known, even if competitor sells a different product or service. For example, if a company were to start selling a cheap line of garden tools called Leatherface's Lawn Helpers, this could potentially dilute the distinctive nature of the famous horror character's name by associating it with a generic, low-quality product. This is what the Evil Dead case was about. The use of the famous name was intentionally confusing and diluted the brand's name. Finally, number 4, the curse of Genericide. This is marks that die of success, basically. This is the most ironically horrifying fate for a trademark. It becomes too successful. Genericide occurs when a brand name becomes the common, generic name for the product itself. When this happens, the trademark owner loses their exclusive rights. Here's a real-life example. The term aspirin was originally a trademark owned by Bayer, but because they didn't successfully police its use And because the public started calling aspirin the common name for the drug, which is acetylsalicylic acid, a court ruled in 1921 that the word was generic in the United States. Today, any company can sell aspirin. Other victims of this kind of genericide include escalator and thermos. Here's the lesson. If you invent a new product, you must use your brand name as an adjective, not a noun or verb. Don't make a Google. Make a Google trademarked search. Don't grab a thermos. Grab a thermos brand vacuum flask. Guard your mark or success will kill it. And finally, trademarks can be nearly eternal. Remember the Ouija board patent posts from last week? I talked about how the patent for the board expired, but the trademark registration for the name Ouija is still actively enforced and perpetually renewable as long as the owner keeps using it, pays the maintenance fees, and submits examples of continuous use with the goods covered. That's the secret. The basic product, a talking board, is available now for everyone to make since the patent expired. But the specific brand Ouija, its logo, and its packaging, the things that tell you who made it, remain protected. Don't let your brand name be hacked up and stolen. Conduct a thorough trademark clearance search, register your trademarks, be on the lookout for trouble, and be prepared to defend them. That's the only way to ensure your brand lives forever. Intellectual property is one of the most terrifyingly useful tools you have. If you're a creator or other entrepreneur ready to build a frighteningly powerful brand, you do need to know how to use it. But you don't have to face the darkness alone. To learn more about protecting your creations, your name, your business, and your legacy, you can book a consultation with me at kingpatentlaw.com. I help entrepreneurs across the U.S. make smart, legally sound decisions about their intellectual property. I'm an attorney in Champaign-Urbana, Illinois, and I serve intellectual property clients nationwide. If this episode helped you survive the horror of learning about how to protect and manage your intellectual property and business, please like and subscribe. You can find all of my other frighteningly good content on intellectual property and business law issues on the King Patent Law website, at Know Your Rights, your IP and business law playbook on all major podcast platforms, and on most social media as King Patent Law. I'm everywhere. The information provided in this episode is for educational purposes only and does not constitute legal advice or form an attorney-client relationship. You should not act on any information presented here without first seeking the counsel of an experienced licensed attorney, perhaps me, for your specific legal needs.